stay here. I don't like these lecterns and all this. As a lawyer, I'm not deep into hierarchy, let me tell you. I'm not going to say a lot because in my experience talking about copyright, the best thing that I can do is answer questions, because there's a lot of particularities about how copyright actually works that there's a lot of misinformation about. There's been a pretty concerted campaign to misinform. And I would suggest that that misinformation campaign is continued by some of the media democracy activists, because the issues, the policy issues, the monopoly of knowledge and the monopoly of culture that Jeff speaks about, I'm not going to disagree with that. I don't disagree with much of what Jeff has had to say. What I'm concerned about are the tens of thousands, hundreds of thousands of artists and creators, individuals in all disciplines, who are deeply concerned about use without understanding, use of their content, use of their work, without understanding its consequences in an environment where funding is so limited and opportunities for remuneration are limited. And, it's almost like sitting here and saying, watching Hart's work and saying we should have a can, and if you like it, drop a loony or toonie or whatever you are motivated to do. In a way, what we need, I think, is a culture that will do that. Most people, I'm sure most of you, are perfectly willing to support Hart and the many other artists and creators out there individually, aren't you? You want them to get paid. Well, we got to work harder at making sure that there's alternative distribution mechanisms so that they can. And I challenge every single person sitting here today to get involved on fighting arts funding cuts in the province of BC or wherever you are from coast to coast to coast. Because the small nonprofit arts organization that is the suite that Hart edits at is in jeopardy of losing its administrative funding because of these cuts. And notwithstanding the nonsense that you hear from the leaders of both the provincial and the federal government, that somehow they've increased funding to artists, that's bullshit. And you and I all know that the vast majority of artists don't ever see Canada Council funding or Arts Council funding. You don't have to be political to see that. So I ask you all to get involved in that fight and to demand more of your post-secondary institutions to get actively engaged in that. Because if we're going to build a bridge, which is where I'm at, between artists and creators who are very concerned about attribution, who are very concerned about preserving the meager royalties they get in some circumstances, not all, but some, if we're going to bridge that gap, then we need to see the post-secondary institutions, the librarians, the activists, demand that a monopoly of culture that we basically have, unless all you ever want to see is Britney Spears and Hannah freaking Montana, power to the people, then get involved in that. And what I want to say about Bill C-32 is really very simple. It's a really, really messy piece of legislation. It isn't going to solve anything that we all experience, whether it's artists. You've heard what Hart has had to say and the disagreements that lawyers have already over whether or not they can show his work on the CBC. I can tell you that, are there any lawyers in the room? Oh dear. Or yay. I like to sort of see myself as a bit of the unlawyer or the anti-lawyer. Deep down, I'm an anarchist. It's true. The bottom line is, I lost my train of thought there. That happens. Is that you can get, we're going to disagree. And the problem with the legislation most critically is that it is an invitation for litigation. No question about it. This government has decided not only that they're going to use this legislation to effectively give a huge hammer to corporations like they had in the United States, which is a huge problem, and you're right to be concerned. But the other major problem with it is that the language in it is so open to interpretation, whether it's fair dealing exceptions, including education. What does that actually mean? How many of you are actually academics, like with positions in the institutions? Oh, come on, I can't see your hands. Thank you. How many of you are prepared to make the argument for fair dealing? In the United States, where they included education under fair use, there are literally thousands of cases still litigated under the education fair use exemption. Your institutions, not you yourselves, but your institutions are risk averse, and they are not supporting you to be making these arguments to them. You need to get a backbone here if we get an education exception, and demand that this is how we need to look at fair dealing. But be aware that we're going to probably be litigating this for another decade at least. This, I don't think, is a good thing. I don't know what the solution is, but I do think that we are arguing almost at cross purposes if I have to put users on one side and say copyright collectives on the other. I don't think we're going to solve this problem. We've been really lucky in this country in that we have had very little litigation. And right now in the United States, there isn't a whole lot, actually, of litigation, particularly against artists, which is a really good thing. But the fear that we have is overstated. And it's continually brought back home to us when we use words like piracy. So if you're talking about copyright and you're trying to explain it, you might want to characterize what, and Jeff was very careful in his use of language here, but when the CBC covered the Bill C-32's announcement, they kept saying piracy. And I got really annoyed, and if there's any CBC journalists here, I wrote into them because it was like, well, this isn't going to help any, because they're reaffirming this very disempowering language, to borrow from Pat Ofterheide, who I'm sure many of you are familiar with in the media studies circle. And if you're not, you should be. She gave a wonderful keynote at the Open Video Alliance conference in New York City this year in Manhattan, which was live streamed and is all archived on the Open Video Alliance website. And I encourage any of you that have sort of the legal issues in your mind to watch what's up there, because there are some really interesting things going on in the US that I'd like to see us do here. But in the absence of any funding to the artist legal outreach, there isn't any ability for us to actually do a lot of the things that we'd like to see. Parody and satire, the reason that I think it's important that we have it in fair dealing is because it is the inclusion of parody and satire led to the concept of transformative use in the United States. There is no such thing in Canadian law. So everything that this guy does is effectively, technically illegal under the law. Doesn't stop him, or Galit, or the many other artists that are out there doing this work, and nor should it, quite frankly. But if we had parody and satire, we could make the arguments to the courts that have adopted transformative use in the U.S. And I think I don't know that it's going to have the effect that Jeff suggests. But, I don't think the law encourages creativity at all. I think, if anything, most artists ignore it completely as a general rule. And my advice, which I'm not giving now, this is the disclaimer part. None of what I'm saying is legal advice, and you should consult a lawyer if you have a specific situation that requires such advice. But it's a risk analysis. If you are indigent, if you have no money, if you do not own a home, and you are effectively judgment-proof in the legal jargon, because we're not going to sue you if there's nothing to sue you for. The vast majority of litigation is between corporate interests. And if you look at the litigation in this country, you will see that it is TV distributors fighting each other over whether or not content is parody. They're not fighting over Hart's work. Where we do have a problem is with YouTube and takedown notices, which are very intimidating. People get them at home, and it's very problematic. It's just an algorithm that seems to identify material. It has not a brain. There's no human person sitting there going, "Oh, geez, that's Prince behind that toddler dancing," in the famous example. Unfortunately, though I think a lot of grown-ups would have difficulty identifying a lot of what is music today, at least, speaking as somebody who's got a 7-year-old, I'm like, what? The problem with YouTube provision is basically it's pandering to you, the users in the world who think that this is a positive thing. It is so flawed and so problematic. It is an invitation for silliness, and I strongly think I think it's unnecessary, quite frankly. It's not necessary. It's designed to prevent the mother of the toddler from being sued. But isn't the real issue, why would you want to sue your audience anyway? And more to the point, I have to hope that the big media companies have learned that lesson a little bit in the U.S. They are not litigating now as much as they used to. There is, in effect, something called tolerated use, and if you Google that, do a Google search, to be trademarkally correct, do a Google search. Google is not a verb. If you do a Google search, then you will find the work that Tim Wu has written about tolerated use, which isn't necessarily a great thing because it's still gray. The more gray you've got, the harder it's going to be to you can't give black and white answers. And the people who control the giving of black and white answers, incidentally, in my view, this is just my personal view, are not lawyers. It's insurers. It's the insurers that are driving this because they're the ones who have to pay when there is litigation. And it is the insurers that are driving the UBC's decisions and SFU's decisions in this respect. It is the insurers, the completion guarantors in film and video. It is the insurers that are driving this and are preventing festivals from doing stuff. They're the problem. What we need is, like we have in the United States, when they brought in best practices for online video use, there was a significant change for documentary filmmakers. It took 2 years of a lot of work, but Cambry McLeod, who made the film Copyright Criminals, I recommend it highly as the film to watch on sampling and not rip or remix Manifesto, which I can talk about ad nauseum if you wish. But the important thing about that is that Cambry said when they started it, they didn't think they'd get to broadcast it. And 2 years into it, they realized that in fact they could and would, because the completion guarantors had adopted the standard of best practices for online video use from the Center for Media and what is the name of the center in the state?
Center for Social Media.
Yes, thank you. So that's my sort of initial reaction to what I've heard, and I would love to answer questions.